Welcome, everyone, to our webinar titled I Knew You Were Trouble When You Walked In with our guest, Esther Macner. Before I dive into details, I just want to say what a privilege it is to have Esther with us today, and to note that we are in the middle of the 9 days, which marks a great Churban, the destruction of the Jewish temple, which was brought about by Sinat Chinam. But I want to say, which is obviously awful, and we should all be kind to each other. I want to say that one of the challenges that we face, which is maybe an addendum to Sinat Chinam, is the sin of indifference. And I feel like a lot of what happens in the conversation around Igun, when women are refused a get and are trapped in marriages, that people throw up their hands and say, I can't, or it's not my problem, or worse, that they are actually indifferent and say, well, this is how it works. And so that's why we're talking today with Esther, who is the founder and president of Get Jewish Divorce Justice, a Los Angeles-based nonprofit combating get abuse and advocating for the rights of Jewish women. She is a former senior assistant district attorney in Brooklyn's Domestic Violence Bureau, and Esther was instrumental in the passage of California's coercive control statute, expanding the legal definition of domestic violence to include non-physical abuse. She also led the revision of the Beit Din of America's prenuptial agreement for California. Esther lectures widely on coercive control, including at the 2021 and 2022 America's Conference to End Coercive Control, the USC Gould School of Law's Cross-Cultural Dispute Resolution Panel, and the Hadassah Attorneys and Judges Council. I'll also say that she lectured recently at the Conference for the International Beit Din that really shined a spotlight on what coercive control is, and how it impacts and its impacts in the legal system, which Esther will talk about also. She also served as an instructor for Break the Cycle, leading workshops for LAUSD teens on dating and domestic violence awareness with a background in psychology, rabbinic texts, and law. Esther brings a uniquely integrated perspective to legal and religious advocacy. So I'm so excited to have you here and to have all of this time, because I'll just say that every time I'm with you, I learn something from you. And it's always in this limited time when you're on a panel with other people. So now we have an abundance of time, and I'm so happy that you can join us. So please tell us a little bit about your story and how you came to do this advocacy work.
Well, my story begins with that I'm a child of Holocaust survivors, and I always felt that it's my duty and mission to protect the oppressed from the oppressors. I come from a Hasidic home, Ger Hasidim, and I always wanted to. I was a Yentl. I always wanted to be a Rosh Yeshiva, but I couldn't because I'm female. And then I discovered I can become a lawyer, which gives me, like secular, I can be a secular, uh, um, rabbi in terms of dealing with the law in a way that is respected. Um, and in my day, this was way before the kind of respect that there is for women's learning today. So I started my law career in the Kings County District Attorney's Office at a time, this was like the late 80s, at a time when domestic violence was a new thing. It was all the way at the beginning of the recognition that domestic violence is a unique kind of crime because it involves a relationship that and is not and requires its own judges and courts and sensitivity um, to the persona of the domestic violence abuser that is focused on a particular victim and requires for courts and for attorneys to understand the process. Why do these women stay? to what extent can you use prior modus operandi in order to make a claim in a criminal case on a particular crime and then bring in prior incidents, which you generally can't do because each crime um, must be determined on its own. Um, I moved to California when I remarried, and I was shocked to learn that um, there wasn't any organization that deals with the issue of get refusal. Um, ARA could not take California cases because they would only take cases in which there is a sirup from a Beit Din. And we had the particular problem of the main Rabbinical Council of California would not send a summons. They do not send a hazmana if a woman wants a get. They will say there's nothing they can do for her unless he's willing to come to Baston. They will also advise the men to wait until the civil case is over, and women to wait until the civil case is over before requesting the get. And they will only send a summons if you are willing to sign an arbitration agreement which submits all aspects of the divorce, including finances and custody, to the jurisdiction of the Beis Din. That will apply halacha, for instance, and not a secular understanding of marriage as an economic partnership, meaning there is no 50-50 presumption of a division of assets, and nor is there, and that's true generally, nor is there any such concept as alimony or maintenance, spousal support after a divorce whatsoever. There is child support and whatever property she brought into the marriage. So I felt there must be an organization that addresses it, and I started this organization in 2012. And now we're like 200, I think we're up to 278 cases later, in which I assisted in getting a get or having women freed, and also assisted in getting a coercive control statute and a case in which a judge actually declared that get refusal is part of the pattern of domestic violence.
So, since we're leaving off on coercive control, I want to say that many people do not know what coercive control is. Can we spend a minute talking about coercive control as a legal measure? How has coercive control become central to adjudicating divorce in the state of California? And how might one advocate for coercive control legislation to be passed in other states?
I can definitely answer that, but I do want to frame this entire discussion because there are so many disparate parts. I want to reframe some central issues so that if you lose the details, you can walk away with an understanding that you can hold on to. I believe that reframing issues is a way of bringing insight into a matter that you hadn't thought of. So, for instance, when we talk about Jewish divorce, I want to focus on not Jewish divorce, but what is Jewish marriage?
Mhm.
And I would say, and this is going to relate to everything we're talking about, including coercive control, but you're reframing what is Jewish marriage? Jewish marriage is conditional. Every Jewish marriage is based upon implied conditions or express conditions. How do we know this? Because the Torah allows for divorce. If there was no conditions as to what makes a marriage, and if those conditions are violated, the marriage has to be dissolved or maybe even considered annulled, then we would be Catholics and we would just say there is no such thing as a divorce, and that's it. So we have to focus on what are the conditions of marriage. And if those conditions aren't met, then we get to the issue of divorce. Another reframing is we talk about deterrence of get refusal in civil law. I'd like to reframe that as we are not talking about religion in America when we talk about get refusal. We are talking about secular, neutral principles, such as uh, uh, you know, when you speak about get refusal and coercive control, you go to the judge and you say, Judge, this has nothing to do with religion. His refusal to give a get has nothing to do with religion. It's only about control. And now let me explain in secular categories what is get refusal. How is it a form of coercive control? There's also reframing of the issues in the sense that we in the United States have a constitution. Unlike the UK, unlike Israel, unlike any other country, we have a constitution that separates religion and state. So we have particular ways of dealing with these issues, which are informed by other countries, but they're never going to be the same, and you have to understand the difference. What are the reframing? Yeah, and in the same way, the prenuptial agreements are also framed in terms of neutral, secular contract principles. We are talking about arbitration, and we're not talking about Jewish divorce. I'll have to get into that further when we discuss the New York prenup and the California prenup. But that was just we're going to get back to this, and everything's going to relate to these reframing. So, getting back to your question of what is coercive control, it goes like this. Traditionally, domestic violence was based on physical violence. Assaults, you had physical injuries, different types. Until Dr. Stark, I think in 2007, based upon extensive research, found that the women who were most likely to be murdered in a domestic relationship could be marriage or, a partner or a child together, are not the ones who necessarily were beat up and went to the hospital. They're the ones who were victims of a pattern of abuse that was not physical. Usually, the physical abuse also includes this non-physical abuse. But if you want to find out, the women who are being killed are the ones that walked out of the courthouse with a restraining order in their pocket. And they're the women who will describe a certain pattern of behavior that repeats itself and a persona of an abuser that can even be predicted. In the olden days, we used to call them battered women syndrome or the Stockholm syndrome, in which a woman is brainwashed gradually into being controlled completely by someone who wants to subvert her will and has done so gradually. And that this is a form of domestic abuse that must be, um, uh, you know, concretized in statutes. And they had been in Europe. They had notions of psychological abuse as crimes going all the way back to 2010 in France and in all of the European countries. They had something called non-physical domestic violence, which he termed as coercive control. What are the symptoms? The intent is to subvert the will of the other party. How? Usually it's with isolation from friends and family. Whatever the support system is of the victim, he isolates her so that she no longer remembers what is good and what is evil. She's isolated. It starts, I mean, when you want to look at, how do you recognize this in dating? It starts with like love bombing. You're the most important person to me. And then it goes to, I'm the best thing that ever happened to you. And I
Mhm.
care so much about you that I want to know what you're doing every minute of the day because I'm trying to protect you. Or, in religious circles, that would be, I'm trying to give you, hashgacha, ruchanius, you have to do things in such and such a way because it's a mitzvah. It's So you have isolation from family and friends. It is control of your finances. This happens, I mean, in marriages, in dating, it doesn't happen that way, but control of your finances so that you need to be completely dependent on him, control of what you can do and what you can't do, whether it's studying or working or just wanting to, I mean, uh, we'll
Or
get
out
to
with your friends.
go out with your friends,
Right.
right? You can't go out with when you're married. You can't go out with your single friends because single friends they have boyfriends and the possessiveness and the jealousy which comes from a sense of insecurity from the guy, but basically you are then brainwashed into thinking this is protection, this is legitimate, this is because he loves me so much. And so coercive control, the big thing about it is it's non-physical domestic violence, like get refusal.
Mm, mm. Um, okay. I want to now take a big leap back. You mentioned dating and love bombing. And we know that it's become the norm for couples to sign the halakhic prenup. So my question to you is, when is the best time to bring up the conversation about signing a halakhic prenup? And do you think it should be a condition before you get engaged or part of wedding prep? And what are other considerations? Are there legal considerations? What should we all know when going in to sign a halachic prenup?
First of all, there's more than one kind of prenup. And there is the most accepted and familiar prenup that we know of is the Beitin of America's uh, halachic prenup, which basically is it has two parts to it. Part of it is a premarital agreement, which states that in the event that and it's an arbitration agreement, but so in other words, let me step a moment back. What is a premarital agreement? What is an arbitration agreement? Both of them have the purpose of resolving a dispute outside of the court system, outside of the laws of the court system with regard to marriage and divorce.
Mhm.
Uh, um, so that in arbitration, you are basically, it's a part of our freedom of contract. You can decide to contract that, we want Daphne to be our arbitrator on all of the issues of X, Y, and Z. So we want her to be the arbitrator on the issue of
Custody.
finances and custody and marriage. And we sign a contract saying that whatever she says we'll accept. That is permitted. That's what arbitration is. There are some safeguards, such as is the is Daphne biased? Is she the sister of the husband who's divorcing me? If she's biased, then it is an invalid, would invalidate the arbitration forum. By the same token, every Beit Din is an arbitration forum. The courts will not look into the merits of a decision. That's totally up to the Basin. Why? Because both of you decided that you want the Basin to resolve this dispute,
Right.
and the arbitration agreement itself will state whether you want them to decide it based upon halacha, based upon New York state law, based upon California law, or a combination. You determine the rules of this arbitration, and the courts cannot undo it unless they find that the forum itself was not was biased, was improper, didn't allow witnesses to come in, didn't allow your lawyer to come in. Now, the issue of the premarital agreement is very important because and this is, I'm going to have to simplify this very quickly, but when I first came to California back in 2009, the Basin of America had a California prenup and a New York prenup. But the California prenup at the time was based upon the Premarital Agreement Act in California. So let me just step back a moment and say that premarital agreements is very recent. It's only like 40 years old. Used to be that you were not permitted to have a premarital agreement. Why? Because it was recognized that agreements between two people who are about to get married is not like an agreement between two companies that are trying to resolve a dispute. Two companies, they're on an equal playing field. But when you're talking about a marriage, there are certain safeguards that have to be upheld because one of the parties is vulnerable. You sent out the wedding invitations, and you and everybody you know is coming to this wedding, and then suddenly, a day before the wedding, he says, by the way, I need you to sign this prenup that basically says that in the event that we get divorced, you are giving up any right to spousal support. In the event we get divorced, you are not entitled to any of my property. That is what premarital agreements do. They step out of the law that says you're entitled to 50-50 of any property that was accumulated during the course of the marriage. They step out of the law, and you've agreed to it. So when I started to study this, I realized that New York doesn't have a premarital agreement. California does. 26 states of the Union have premarital agreements. New York is not one of them. So that New York, it was less of a problem to have the premarital aspect of the agreement, which says that in the event that we want to divorce, and I call you to a Basin, for every day in which you don't come, you agree to pay $150 a day. Why 150? Because it's reasonable. It's not, halachically, it can't be considered a penalty. And it's a reasonable amount of money that you have already agreed to pay when you signed a ketubah that says, I'm going to support you, that you've agreed to support you. So this is not something new. It's simply enforcing what the ketubah says anyway, and it's going to be for this and this amount of money. What happens? What happened in California? In California, there was a premarital agreement act stricter than all the other states that basically said, if it's a premarital relationship, we are not going to allow an agreement unless each party has their own attorney. We're not going to allow for an agreement unless each party has submitted comprehensive financial information, meaning, according to the act, you need to have disclosed to the other side all of your income and assets, everything that you own, so that when you're signing a premarital agreement, which there was a lot of in California, it makes a lot of sense if you're a movie star marrying your secretary that you have an agreement that's going to preclude the secretary from taking from getting care of your assets. It works and is important for a second marriage in which there are children from a prior marriage, and the
Right.
children need to be protected. You want to be able to leave some inheritance to your children. If you're not going to have a premarital agreement, then half of it goes to the new wife or whatever. And therefore, there had to be protections because one side is very vulnerable. So when you come to the premarital agreement that the BDA had for California, if it were challenged in court, it would be deemed invalid. Because I ran around to all the rabbis here and I said, "Do you have any idea what, the premarital agreement then at that time said that, we have disclosed, that we have decided both parties were informed they should get themselves a lawyer, but they've waived that, we've advised them they can get a lawyer, but they decided not to." In California, that waiver of having an attorney is illegal. It's considered unconscionable to begin with when it comes to a premarital agreement. Doesn't matter that you've decided that you don't want it. It's I'm sorry, I lost you. Where am I?
No, no, you're still here.
Oh, okay. So I can't see you because I got a call. So let me just go back on Zoom.
Okay.
Okay. So it doesn't matter that you thought that you waived this right. We don't accept it, and this agreement is invalid. So uh, back in 2000, it took 4 years for me and other attorneys like Alexandra Leichter to converse and do research together with the Beitin of America of how to make a prenup, a halakhic prenup, valid and enforceable in California and other states that don't have a that have a premarital agreement act, and each one is different. The conclusion is it is an arbitration agreement only. It is an arbitration agreement, and it states that this agreement does not override any laws having to do with distribution of property. It does not over. It has nothing to do with custody. It is it is an arbitration agreement. And when we talk about a mizonot, a daily amount, this is a Jewish thing that only the Beit Din can decide upon. It has to do with Jewish law, has nothing to do with support, with the secular support laws in California. And this way we have an arbitration agreement. Also in California, in order for an agreement to be valid, it has to be reciprocal, especially a premarital agreement. It can't just be that the husband agrees to do X, Y, and Z, and the wife nothing. It had to be reciprocal so that it is reciprocal. If she calls him to the basin, he has to pay. If he calls her to the basin, she has to pay.
Right.
So that it is not so that there is consideration here. And the California prenup was rewritten. Uh, okay, so what was the question about?
Wait, can I just ask a follow-up to
Sure.
that?
Yeah.
So you just said that if she calls him to the basin or he calls her to the basin, is it that the parties or the basin has to issue an invitation?
No, the parties have to inform the basin. There's a notification because otherwise, you don't know when the clock starts. They have to inform the basin and the other side. I've gone to the basin and I'm calling you to basin for a get because we're not living together as husband and wife and there is no hope for reconciliation. Then, for every day in which he doesn't show up, the clock starts ticking. Likewise, the clock starts ticking for her. And there are some men, I've had two men that were victims of get refusal by the wives. Uh, they have other outs like hetemerabanim, but that's a whole different
Right.
thing.
I don't want to
But
go down that rabbit hole
nonetheless,
right now.
nonetheless, yes, you have to inform the basin now. What happens with that premarital agreement? The arbitration agreement. The courts will enforce an arbitration agreement. That means that if you have an arbitration agreement and you go to court and say, look, we signed this arbitration agreement to resolve the issue of the Jewish get or whatever it is, the court will force you to go to the arbitrator to resolve that agreement because that's a contract. It's a secular, neutral contract
Right.
that you've decided to contract with the Beit Din, this particular Beit Din, to go and resolve it. So they'll force you to go to the arbitrator. The arbitrator, the Beit Din, then comes up with a psak. And their psak, if it is a monetary psak, will be enforced, meaning it is just like having gone to trial in a court of law and having a monetary amount decided by the court or the jury or whomever that this one owes the other one, if it's about $50,000 a year, this person owes the other one, it's a debt having nothing to do with spousal support or anything else. It's a debt. And you can then um, turn it into a money judgment. You just have to bring it to court for them to approve. And that is not a halakhic problem because the Torah, the Gemara really says you can't go to civil court to adjudicate your claims. That's a whole different other thing. You're not allowed to go to a Gentile court. However, if you go to a Gentile court, in order to have the Gentile court tell you, you have to do what the Beis Din told you to do.
Right.
That's the halacha, and therefore it can be enforced.
Very helpful. So I want to we talked about the considerations of the prenup. I want to switch to the ketubah. And a lot of people consider the ketubah to be a marriage contract. Is that a correct understanding? And based on the ketubah, what are the responsibilities in marriage and who does it fall to?
Okay, I mean, there are different opinions on this, but this is my conclusion based on my studies, and it's like this. The ketubah is very ancient. We don't even know where it began. It definitely began before the Mishnah, before the written oral law. And the Gemara asks, where did it come from? And the answer is it came in order to protect women from from men who will arbitrarily divorce them on a whim. In other words, for Chazal, the big problem was uh, uh, how to protect a woman from being divorced against her will.
Right.
Unlike the problem today is how to protect a woman from being forced to be in a marriage against her will. In those days, it was being divorced against her will. Why? Because according to halacha, strict halacha, um, marriage is statutory. And what the ketubah said was, we are you have to sign an agreement, which is really a postnup. In other words, there were two parts to a marriage. There was Erison and Nisuin. I won't go into it. Basically, before you got married, Chazal decreed that you have to sign this prenup called the ketubah.
Mm-hmm.
It is different than the shtar. People think that the ketubah is the marriage contract. It is not. It is, the Chazal say there are three ways that you can acquire a wife. One is by contract, one is by money, kesef, and one is by intercourse with the intent to be married. Those options, except for kesef, are no longer halakhic. You can only marry a woman by way of giving her something of value, like the ring,
Right.
and stating that I'm giving this to you for the purpose of marrying you, and that communication is witnessed. It isn't just that they observed. That communication is uh, um, is witnessed by two kosher male halakhic witnesses that saw her and heard him give her something of value for the purpose of marriage. That's what makes a marriage. If you don't have a ketubah and you have a chuppah v'kiddushin, you are still married. If you lost your ketubah, a ketubah will be implied. Now, what is the chiddush here? From my understanding, um, the decree that every marriage must have a ketubah. You can't live with your wife without a ketubah. I believe came about because rich women would say, "What? I'm going to have a public declaration that that I need to have. I'm a wealthy woman from a good family, and I'm going to have someone read out the ketubah that says that in the event that we want a divorce, I don't trust my future husband's family that I will be supported. I don't need this. I have my own support. I'm an important person. I'm an important lady. The ketubah would have been just a document with a stigma that this is only for poor women, or this is not for us. It's not for unzera. We trust each other, etc. We're both distinguished families. No, every single marriage must have a ketubah. This way, it became standard, and
Right.
not a matter of this is a document for certain kind of people, not others. In that way, I always say that people don't want to. People, what do you do when your husband doesn't want to sign a prenup, or you don't understand it? You have to think of it in terms of this is something that I'm doing for Klal Yisrael. It's not that I don't trust my wonderful husband, but I need to make sure that the other group of women will not feel stigmatized when they have a prenup. And that's why many of the modern Orthodox rabbis, the YU rabbis, won't marry you without a prenup. Why? Because what does the prenup say? It basically says, I respect you, I love you, and so much so that if whatever happens between us, like we find that we need to divorce, I will not harm you. I won't harm you. I won't harm our children. This is a romantic love agreement that we trust and respect each other, that we treat each other with dignity within the marriage and beyond, if God forbid that happens.
I just want to say that when I got married in 1999, we signed the halakhic prenup, and we had so much pushback from people who thought that it was bad juju. What were we setting ourselves up for divorce? And we kept saying, nope, this is meant to normalize having these conversations before you get married, and to normalize this process, whether, I believe probably it's been revised since 1999. But to normalize this so that this can be, this raises the conversation amongst couples, but also that this can be a tool that helps to prevent people from being stuck in marriages that they no longer want to be in.
I would
So
just say very quickly that there are other kinds of prenups. The Hasidic community have there's a Yashar agreement. They do not believe in having any monetary penalty. They call it a penalty, even though it's not a penalty because you're agreeing to it. It's a contract to simply enforce what the Ketubah says, according to the BDA. It is deemed It may be deemed coercive, a get mausa, and so they have a different form. Any form of an arbitration agreement is good, because it does at least bring you very quickly. I mean, the Ashar agreement takes care of some issues like the Basin has to decide on the first meeting, how are the children going to be taken care of during the divorce process? Because if you're not allowed to go to secular court to get temporary support, you're finished. And so, it tried to do. Then there's also another kind of agreement, which I believe would be the solution to the Aguna problem forever, which was first introduced by Rabbi Michael Broyd, the tripartite agreement, and is adopted by many others. It's basically a conditional marriage prenup, which is something that occurred throughout history. You find such ketubot in the Cairo Geniza that basically says, I'm marrying you on condition that we are living together as husband and wife, and if for any reason we're separated for over 18 months, this document is I authorize anybody who, forms a beit-din to consider this document an authorization to give you a get. It's the kind of thing that they say was given to warriors going out to war in the time of David HaMelech, and is something that some people do in Israel at this point. But anyway, that's way, way beyond the purview of this
Yes.
conversation.
Related, but there's also now that we're seeing because of the war in Israel, a lot more conversations about Yibum and Chalitza, but that's a separate conversation. Just that, these ancient problems with ancient solutions, are still relevant today. So I want to ask you a nuts and bolts question. When a couple decides that they want to get divorced, what's the best practice? Do they go to, and we're talking in North America. I know Israel's a different thing. Do they go to Beit Din first? Do they go to civil court first? What's the number one piece of advice to share about, and also once you're going to Beit Din, what's the number one piece of advice to share about dealing with the Beit Din when it comes to getting a get?
Right. So I would say it depends on which beit-din, and it depends what your issues are in the divorce. Generally speaking, strictly speaking, Jews are not allowed to go to a Gentile court to resolve disputes. They must go to a Jewish court. Unless they get permission to go to a Gentile court, it's called heter arkaot. So generally, even in the most, ultra-Orthodox communities, if there's an issue of, hopefully, if there's an issue of domestic violence, and the Beit Din well knows that they do not have the power they don't have police power of law enforcement, they will immediately tell you, you have permission to go to the secular court to get a restraining order and whatever needs to be done in terms of a criminal action. But it's circumscribed to that issue alone. Now we come to what beit-din. You should look for a beit-din that believes that marriage is an economic partnership, meaning, unlike strict halacha, in which marriage is not an economic partnership, meaning when it comes to money matters, she is entitled to all the property that she came into the marriage with. That's her separate property. And any monies that she's inherited during the course of the marriage. And if she's going out to work, she's entitled to the money she earned, but that also is in question because there's this statement saying, Masha kana isha kana baal. In other words, anything that she owns belongs to him.
To him, right.
So that even if she has her separate property, he must, if they get divorced, return that property in full, the amount it was when they got married, but he can use the usufruct, which is a legal term for um, for the benefits of the asset. So if she came in with a big apartment building, that belongs to her when she leaves. But in the meantime, he's entitled to all the rent. Now, when it comes to money matters, halacha does conform to what is the, what is the use of the trade in your community, minhag hasocharim, and that there are many batei din, like the Beit Din of America, like I understand Rabbi Ullman's Beit Din in Australia, like the rabbinic courts in Israel, that have adopted the notion that marriage is a 50-50 partnership. So what's a partnership? A partnership is you start a company, and if the company dissolves, each partner is entitled to all of the company, meaning each gets 50-50. So for instance, in the RCC, they don't believe in economic partnerships. So if you're going there, you would need, and there's a lot of property involved. I always tell people to go okay, let me start with this. When should you go for your get? As soon as possible. That's my answer. What does that mean? Informally, you should be immediately texting, writing, saying, look, we've been separated. There's no way we're getting together again. Let's make an appointment for the get. So that you get in writing his response. Well, I don't want to give you the get unless I know that you're going to waive your right to the house.
Right.
Okay, so you have a text. Or I'm not giving you the get until I know I have custody of the children. So you have evidence of some form of conditions which are really extortion. Or you find out what is the reason why he does not want to give a get. You need to get something in writing. Now, when you go to you should go to a Beit Din that will serve a hazmana, that will serve a summons for the issue of the get alone. So that if you ask for a hazmana for a get, go to a Beit Din that will issue a hazmana. Most
Right.
Batei Din do not.
How would you know that in advance?
Uh, talk to me.
Okay.
No, but how would you know that in advance? You can just call and ask. And I can tell you what would happen. You would call and ask, can I get a hazmana? I want to get. And when you would call the RCC, they would say, is he willing to come? And, you say, I don't know. So they write an email saying, your wife wants to get, are you available this and this time? And he says, no, I don't want to give it. Or I'm not going to give it until whatever. No, I'm not interested. They will come back and say, I'm sorry, we cannot take your application. We cannot issue a summons unless you are willing to sign an arbitration agreement in which, if you've been to secular court and already have rulings there, you have to remove everything from secular court and give everything to our jurisdiction, both on custody and finances. So you need to find out whether or not, so the Beit Din will tell you, you need to find out, is this a Beit Din that's going to rule on custody, even though you already have a case in family court, or you're afraid that the children will be harmed? They will tell you. Call the Beit Din and say, I'd like to have a summons. They'll tell you, no, we don't do that. We don't send a summons.
Right.
Now, in California now, I have Rabbi Teichman who started to send summonses, and it's made a huge difference. Because without a summons, you have no evidence that you ever asked for a get.
Right.
And so when it comes to coercive control in California, and you come to court and you say, his not giving a get is part of the coercive control. Usually it's a pattern of behavior, and this is part of the behavior. And he comes and he says, what are you talking about? I never said I'm not going to give her a get. Of course, it's been 3 years since he hasn't done it, but she never asked me. I was never called to a beit-din to give a get. Who said I'm not giving a get? It's not true. So that's why you need to have formal and informal. Also, it's important to have a summons for the new Israeli law since 2018 in Israel. Any get refuser, male or female, any get refuser who has gotten married according to halacha steps foot in Israel, even though that person is a foreigner, not an Israeli citizen, and
Right.
doesn't have any property in Israel, the rabbinic court in Israel will take jurisdiction over that case and issue a tzav ikuv restraining him from leaving the country without going to Beis Din, on condition that you can show that you have tried to get the guy to Beit Din for over 4 months and he hasn't shown up. How do you show that without a hazmana?
Right. You have to create your own paper trail.
You have to create your formal paper trail.
Mhm.
So, for instance, I had a case with the RCC in which there were 2 hazmanas sent out, and the guy was in Israel, and I said, this is urgent. You have to send, you have to send a letter to the Beit Din. And the response that I got was, we don't do letters. That's not professional. We do a seruv. If he didn't show up for 3 hazmanot, we send a seruv. We don't do letters. The guy left the country. The guy left the country, even though, I had Yad La'isha waiting in the wings to open a file in the rabbinic court. And at the end of the day, she was freed through the International Beit Din that declared that her marriage was void to begin with, because the husband had a mum gadol, a
A great blemish.
great blemish, which is one of the conditions for the dissolution of a marriage. He doesn't have a great blemish.
Right. Whew. We have a couple of questions from the audience that I want to pose to you before we wrap up. And one of the questions has to do with something you mentioned before, about extortion. And the question is, what about if the ex-husband puts financial, like, tries to, there's financial abuse, and he threatens to take her to debt court for financial judgment?
Unless, in other words, uh, well, then the question is she in debt or not? Does he have a valid financial claim or not? Threatening somebody to go to a debt court simply means you owe me money you didn't pay, so I'm taking you to court. If it's in the context of, unless you give me something I'm not entitled to, I will call it a debt. But it is really something I'm not entitled to by law.
Mm-hmm.
Unless you give me that, I'm not giving you a get. That's extortion. And that can be, used. I would just want to say, I realized one other thing in terms of a beit-din.
Mm-hmm.
You have to go to a beit-din that will allow you to tweak the arbitration agreement, the shtar barurin, to say, I'm coming to the Beit Din for the matter of the get only, and that the custody order already decided in court remains within the jurisdiction of the court, and to cross out anything that says that all prior agreements can be reopened in the Beit Din. If they don't allow you to do that, that's not the Beit Din you want. Okay, I'm sorry. Getting back to your
That's
question.
okay. Also, I just want to give one plug. People should definitely call you. There is also an online resource that was organized by Chochmat Nashim called Rate My Beit Din, and there you can go and get pretty recent feedback about people's experiences, women and men too, regarding Bate Din, really, I think all over the world.
Right. And I am in the process of providing them with the information I have with regard to these issues on the But They Did.
Yeah. Let me ask a different question. Do you see any difference in of get refusal and coercive control between the younger generation and previous generations? In the cases that you see, has the age range changed, or are we still looking?
Oh, I definitely think it's not so much the age range as it is the culture of the community in which you live. So, for instance, in Los Angeles, we have a huge Persian community. It's called
Mhm.
Tehrangeles for a reason. And culturally, young and old believe that men have the prerogative to set the conditions of a marriage, and that getting divorced is just out of the question because it will bring great shame and dishonor to the family. So uh, and that the woman is the one to blame. If he's beating her up, she must have done something
Right.
to deserve that.
We've heard these terrible, terrible arguments before.
Right, right. Now, younger people, I think, younger people, I'll tell you something. The big change, I think, that is this in the Hasidic frum community. Ever since the explosion of social media, frum women have a voice that they didn't have before, because now they are talking to each other and to the world at large without asking permission from the rabbis. They are they are putting forth what they believe, what their experience is, and what you should accept and not accept, and what are the signs of things that you should not accept, and why you're entitled to your own autonomy, why you're entitled to work or to decide what you're going to wear today, or what color dress you're going to wear, or the fact that you want to go visit. If somebody in a dating situation refuses to go out on a date with your friends because they don't want to be looked over, or they don't want to go to your family. Maybe they have to go once, but you don't want to, your family doesn't really care about you the way I do. And I don't want to waste our precious time that we have together by spending it with other people. That's a sign that this person wants to completely isolate you.
Right.
I think there's much less of a chance of isolation, thank God, because women have taken to social media and are talking.
I'm glad something good is coming out of social media. Esther, I'm looking at the time and I can't believe that we've been having this conversation for an hour. I want to thank you. Is there something you want to share quickly and concisely to wrap things up?
Um, I would just go back to reframing the issue. We have conditions in marriage, and those are halakhic. The Torah is compassionate. There are solutions that are just not being used, that were used in the past, that were used. It was easier for a woman to initiate a divorce in the time of the Gaonim than it is today. The Torah is compassionate, and it's either the interpreters of the Torah or the men who use Torah as a perversion to do things that are not Torahic. We are compassionate people, and we have solutions that must be used.
Amazing. I want to thank you for taking the time. If people have questions, they can contact you through your website at Get Jewish Divorce Justice. And you are doing amazing work for Am Yisrael. And I want to thank you again for joining us today.
Thank you.